Hey guys, Dwayne here. Today I have something really special for you. I've been working on this for a couple of months and I've been teasing it for the last couple of months. But we were finally able to do it. It's an interview with Joe Cordell from Cordell Cordell, a domestic litigation firm that specializes in family law for men. A lot of you guys have had questions about specific legal issues, and they had reached out to address some of those concerns and some of those issues, and Joe was able to take some time to talk to us and cover some really great topics. So some of the answers were I was surprised by. A lot of it was just kind of validated what I already knew. And I think some of his techniques and tips on how to address this, especially when we're dealing with an undiagnosed person with a personality disorder, or who we suspect have a personality disorder, he had a lot of great advice on how to deal with that to maximize addressing the actual issues and not getting ourselves into additional problems. So let's just dive right into it. I hope you guys really like the interview, and let's jump into it. Today we're joined with Joe Cordell from Cordell Cordell, a domestic law firm specializing in family law for men. So thank you, Joe, for taking the time to come on the channel and talk to us. I really appreciate it.
My pleasure. Thank you for having me on, Dwayne.
Great. Hey, can you talk a little bit about your organization and what you guys do, and go into a little more detail about what you guys specialize in and what your goals are?
Well, Cordell Cordell is a domestic relations firm that's dedicated to representing men in domestic relations cases. Interestingly, about probably 2% of our clients, maybe even in some years as high as 3%, are women. But we're happy to represent women when they come to us, but the bottom line is that the firm's mission is to focus on helping guys in domestic relations cases. And we have probably, I'm estimating today, we have about 230, 240 lawyers. We may very well be the largest domestic relations firm in the United States. I'm pretty confident we are. But we started in 1990. So we're pretty far down the road at this stage, and we've really been blessed with a lot of growth and success.
Do you guys have, I know you have a lot of attorneys' offices in the United States, and I look for California, but do you guys cover every state, or are there still some gaps?
There's some gaps. We're in, of course, the larger states. We're typically in states where there are cities of 1 million plus population. But we're gradually creating a presence in every state, but it's been slower than we would like.
And I've also had some viewers who I've talked to on the back end in preparation for this, who have indicated that you guys have now expanded into at least England or the United Kingdom, so that's exciting.
It's very exciting. As a matter of fact, now we're an international firm, and it's something that came about in part because, we, like your audience and we notice in the news stories relating to men and frustrations that men might have and domestic relations issues, and we knew that in the UK there was this growing frustration among guys that they felt that they weren't getting treated fairly in domestic relations courts, especially relating to custody.
Yeah, that's been the experience I've had in discussing it with some of the viewers. So hey, I had a couple of things I wanted to go over with you, and I know my audience has been really excited to get some professional legal opinions on some of these things, and I'm really looking forward to what you have to say on it. So I'll dive into it. So, do you feel the family court is changing its view on child custody and fathers' rights, and where do you think the court is actually heading on this?
I think that there's been improvement. There's not been the sort of improvement that we're all entitled to expect, but there's been improvement versus, say, 20 years ago when, we were having to routinely slug it out in courts for even reasonable consideration for guys in pursuing primary custody. But there have been some statutory changes in a variety of states. Judges have become more enlightened. Perhaps some of that is that some judges now are a generation younger than judges before. So I can say that the good news is there's been progress. The not so good news is the fact that it's nowhere near where it should be.
Yeah, I know when I started my situation, the opinion I was getting from my attorney and just people I knew is that the likelihood of getting 50-50, which I ultimately did, would be really expensive, and it wasn't a guarantee. And I ultimately did get 50-50, so I was very fortunate in that.
Good
but
for
yeah,
you.
it was not an easy experience. So
No, it typically isn't.
So the next thing I wanted to ask you is, so on my channel, typically it's talking about personality disorders and how they relate to the situations of divorce with children. So, most of my viewers on my channel are dealing with either covert or overt narcissistic, abusive, basically emotionally abusive exes. Does a family court actually recognize these personality disorders, and how does it have any influence on child custody?
Well, certainly experts are used a lot in custody battles, but they're expensive. And
Yeah.
often, a person who's on a tighter budget in a divorce, which the vast majority of people are,
Yeah, that was me.
then the refuge they take is to point to behavior. So sometimes it's accomplished by virtue of establishing that there's this unacceptable behavior that doesn't require perhaps a diagnosis so much as convincing the court that this is not in the best interest of children. And at the end of the day, that really is what the elements in custody battles in virtually all the states have statutes that point to considerations the court should have for behaviors that are threatening to the children's best interests. So at the end of the day, it's going to have to be expressed in the form of behavior. So if you can put evidence on that demonstrates this destructive behavior, then the label might be less important to achieving the end.
Yeah, sometimes I was worried that by using the label, it could actually, I get that it's a balance, right? In my opinion, and in my situation, I was trying to make sure that if you had, that I didn't fall into the stereotypes of, okay, you got the two people and they both hate each other and, they're both being unreasonable. I was trying to be reasonable. That's why I didn't go in and say, well, one, I didn't understand the whole personality disorder issue. But I also didn't want to go in and say, well, we've been married for 20 years, but now she's horrible and I should have full cut. That's that tit for tat type thing. So that was, I guess, one of the comments I also wanted to, I guess, make and ask is, and one of the things I've told my viewers is, when you get in these situations, you really need to be aware of what's going on and remain calm so you don't fall into it. So when you're talking about that pattern of behavior, that you're not showing the same thing, right? Because then it's counterproductive.
Yeah, and it is, you're right when you think a lot about your credibility to the court. There's all too often a tendency, particularly on the part of judges who are jaded by having sat in that bench for a decade plus, and suddenly their eyes have glossed over, and so they're starting to categorize everyone as being equally at fault. And the tendency is to say, they're unreasonable, meaning husband and wife, as if the underlying assumption is that they're equally responsible for these problems. And rarely is that true. The reality is that normally, as you might expect, somebody is more responsible, and more often than not, somebody's a lot more responsible. And so in order to overcome perhaps that propensity that many judges have is to, think a plague on both their houses is to convince the court that I'm the reasonable one, judge, and there is a dramatic difference here. And I'm not here because I want to be, so to speak.
Yeah, no, that's a really good point. And I appreciate you saying that, because I think that people need to understand that, have realistic expectations, and also go in with it with the right mentality, because I think it improves your opportunity for success.
Yeah, you're right.
So on that, I had some viewers a few weeks ago ask a question. I wanted to ask you this: so some of my viewers have expressed a desire to actually call Child Protective Services, CPS, when they feel their children are being emotionally abused by a covert narcissistic, ex or parent, but not really physically abused. And is that really an appropriate course of action? And what are the pitfalls if someone was to actually go down that road?
Well, in a way, this gives me a chance to come back and make a point that ties in with the previous question, and that's that sometimes the use of those labels is worse than not helpful. Sometimes it results in the court, concluding that this is one of those people who psychologize everything and who perhaps throw labels around, recklessly. So use of labels like narcissism, you have to be prepared to give a lot of professional support if that label is going to be used. And more pointedly to your question, it's a dangerous course of action to make allegations of abuse. At one time, that was the currency largely used by mothers, especially in divorce cases routinely. And it became a method by which they would gain an advantage and ultimately a victory for primary custody. Over time, though, courts reacted sharply to that. And this began really coming into this century. Courts began to recognize that this is worse than a little harmless if overstated or if manufactured from whole cloth. This is worse than harmless. It's actually a form of alienation, and it can have substantial effects that resonate in the children's lives for many years. So now courts, whenever someone rings the bell of abuse, courts will look, but if they fail to find anything other than the cry of wolf, then often it results in the court taking corrective action against the accuser. So
that is actually really good news, actually.
Yeah, I caution clients to be very careful before they allege that abuse. There's got to be some evidence that can be pointed to.
Now, I have a few viewers, and this is obviously still an ongoing issue for folks, with the temporary restraining order, right? I've had a lot of people who get nailed with that, and they get really scared. What I've been telling them is like, look, typically unless you've done anything to just because someone says something doesn't necessarily make it true, and as long as you're not doing anything to validate it, typically that TRO will get thrown away. And most people who've interacted with me on the channel, that's been their experience, is they'll be labeled that, they'll deal with that, and then when they finally get into court, and sometimes that takes a long time, typically the judge has, and the people who've discussed it with me, has disregarded it and wrote it, I don't know what the right word is, but dismissed it, and then things progressed in a more normal manner. So I guess what you're saying with that is that's kind of a new change in the last few years where the courts are starting to realize that this is just being hyped up.
Yeah, orders of protection. Orders of protection are virtually always filed under the Adult Abuse Act. So that's separate from the Child Abuse Act.
Okay. Okay.
Making an allegation of child abuse, which is what would be the appropriate claim in the scenario we were just talking about.
Oh yeah, okay, exactly.
That is the one that triggers very grave consequences for both sides of the table, depending on the evidence.
Okay.
But as to adult abuse orders, those have been a source of complaint by us in courts across America where we have attorneys, and that's that they're routinely abused, meaning the statute is abused. It becomes, in effect, like a battlefield nuclear weapon in the hands of one side of the table, but not in the other. And while I don't completely disagree with you that some judges who, especially those who are more enlightened about these incentives, will readily recognize the sort of mischief that comes from positioning in court and dismiss it. But I would argue that while it may not be a substantial minority, I would still argue that it's a minority, meaning that more often than not, our experience are that judges will effectively shift the burden of proof, not formally, but effectively. They'll shift the burden of proof, which should always be with the accuser, to the person who's in court defending himself. And it's easy to understand this. This is human nature. Judges, if a judge makes one wrong call, there's only a chance for one error by a judge where he fails to issue an order and there's subsequent violence done to that woman, for example. And judges are very conscious of this, and they're determined that their careers are not going to end in infamy. And it's much safer to issue an order if there's any doubt than to not issue it. So suddenly the burden on the accused when they enter court that morning and a docket of often 30 to 40 people on a docket where the judge may have set aside 2 or 3 hours, as if that's going to give due process and equal protection to the accused. And in that frenzied environment, one of two things happen. And 9 times out of 10, it's the first. The first thing is there's a deal offered where the accused, always the guy, where the guy can sign a document where he agrees to the order being issued, but not to a finding of guilt, not to a finding that he's guilty of adult abuse. He avoids having his career end, as it might in a number of professions. His life would change regarding ownership of weapons and various other licenses and other things that he might pursue. The ramifications are substantial in a variety of different fields and ways. He avoids all that by acquiescing to an order in which he agrees to stay away, et cetera, et cetera. And an order that will impact his probability of success in a custody battle. But it wouldn't quite be the death knell that it would have been if he had gotten on the stand and had a trial. Then the other possibility is he asked for a trial. And that is a risky proposition. But you're right, we tend to be aggressive. People come to us because they want us to be aggressive, and I can say, I can report happily that in more often than not, we're successful, but by no means could I boast that it's a sure thing to step on a stand where it's your word against hers, and that's all the judge has in 90% of the cases, and a judge who has the incentives that I just described. I mean, it's not a scenario that's designed for fairness to the accused. And men across America who've never been accused of any sort of violence suddenly find themselves thrown out of their homes without a hearing and maybe getting into court in the statutory 15 days. Typically, incidentally, it ends up being 25 to 30. So here this dad and respected citizen is maybe sleeping on his parents' couch or staying at a friend's house and trying to avoid anyone finding out in the workplace where he might be a manager or in other positions of responsibility, and waiting for his opportunity for a hearing, and the hearing is the scenario that I just described to you. I mean, by no means is the adult protection order, while the underlying motive perhaps might have been good, the result on the ground is not.
So bottom line on that, if somebody's dealing with that and they get into that situation and they don't have an attorney, they need to get professional help rapidly to ensure, increase their opportunity for success.
They do, yeah. They should definitely have an attorney because the consequences are so grave. And for some guys to be as confident as they are in their abilities, and I argue that one reason guys have difficulty in divorce is because they tend to think they can handle it in ways that they can't. And so a lot of guys will swagger into that hearing thinking that, well, if a judge just hears me, obviously this will be dismissed. Well, it's not so obvious. And so in response to what you just said, I would completely agree. It's good to talk to a lawyer and have a lawyer on board.
Okay. Well, and this actually segues into the next question I had, which was, in narcissistic abuse, and I just to parrot what you just said, and I've said this to my viewers too, going in guns a-blazing talking about personality disorders and cluster B and all that stuff is probably not in your best interest unless you have an attorney who understands it and understands that local court, and if it's something that they accept. Otherwise, you could potentially, like you said, put yourself in a box and hurt yourself. But false allegation and smear campaigns are very typical of narcissistic people. So what are the most appropriate ways for a person to actually defend against that when they are being smeared and there's these false allegations going on? I mean, what should someone do on that? Well,
let me make this description, this scenario, a little worse first, and then I'll respond in a more constructive or helpful way. Another issue, though, that I think in effect is an incentive for this sort of mischief with the truth in divorce scenarios is that it's virtually unheard of that anyone is prosecuted for perjury. I mean, I can think of at most, I can't even fill one hand with examples of that I know of directly. As a practical matter, there tends to be a sort of cynical view regarding people's tendency to tell the truth under oath in courtrooms when it's family court. It's taken more seriously in many other scenarios, civil trials, criminal trials, etc. But sadly, in family court, it's almost as if many judges expect that both parties will lie if they think it will serve their interests, and the challenge of the court is to sort through and figure out who's lying the most. And when you have that sort of low bar, then the temptation of people who know the system is to work the system. Now, what do? The only way that you can combat that is to accumulate evidence. It's not simply enough, although it sometimes is, if your client, if the husband or the wife, whoever we're talking about, has the credibility to get on the stand and to look the judge in the eye and to explain with the sort of passion and credibility that some people have their case and be believed. I mean, that's a gift. And you know if your client, I know when I have that client usually, and I know incidentally too when I'm doing a deposition, and the other side has that characteristic. You know, you can see that some people are wonderful witnesses. Doesn't mean incidentally they're always telling the truth. But it is very helpful to have that going for you. But additionally, you know, it requires having a lawyer who's prepared to roll up his or her sleeves in conjunction with the parent and put in the legwork to assemble the evidence to establish, you know, the truth. And here's the good news about establishing that someone is a pathological or a habitual liar, is that you only need a few examples. You don't have to have 50. So what we'll do in litigation is we'll identify what are those 2 or 3 points that mom is making. In my case, I'm representing guys, but I know that your audience is at least as many women. So this message would be true for either. Is for the parent in conjunction with his or her lawyer to identify those 2 or 3 allegations that you can really shoot down demonstrably to the court and without a lot of cost in litigation. Because once you've done that as to significant or important elements, then you've effectively damaged their case in its entirety. And then you're in a position to argue through your attorney that judge, this illustrates the fact that virtually all of what's being said by the opposing party is untrue. And then you can maybe take that additional step to attach a label to it. But to attach the label in advance of establishing the fiction of much of what they're saying, it will have the potential adverse effect that you described a few moments ago, where it actually harms the credibility of the accuser.
So basically, just stick with the facts. If somebody is acting a certain way or are doing certain characteristics, identify that. And I wanted to ask a little bit more about evidence, because there has been some discussion on how you do that. Like some people have said, you know, just keep a journal. You know, keep a journal that says on this date this happened, or they did this to the kids, or whatever. What type of evidence would, if I was your client and I was trying to, you know, you were asking for this information, what would you expect from me to provide you to be able to argue that point and have the evidence to demonstrate that?
You raise, incidentally, you ask very good questions. I do a lot of interviews, and often, you know, the sort of meaty questions that you're asking, I'm not asked. So I appreciate that.
Thanks.
On this point, I can tell you that keeping a journal is hugely helpful, but you have to be careful what you put in it. To the extent that the person starts keeping the journal as a result of their lawyer telling them to keep it, then it is protected, meaning that it has a privilege. It can't be subpoenaed by the opposing party, or it can't be forced to produce it to the opposing party.
Oh, okay.
But you want it to be in a situation where you can quote from it. And in order to quote from it, this sounds circular, but in order to quote from it, then the opposing party has the right to see what you're relying on to refresh your memory, or et cetera. So here's the quick answer to that point, is to say, yes, keep a journal, but only put facts. Don't use emotive words like that jerk came by to visit me. Instead, it's my husband came by to me, or he screamed like a maniac. No. He raised his voice so loudly that a neighbor came over to see what was going on. In other words, everything should be with a reporter's objectivity.
A business type view.
Exactly, so that there's nothing more powerful and nothing more credible than a witness sitting on the stand, and when asked by their attorney in a custody battle especially, you know, were there occasions when Mr. Smith was not was not attentive to the children at a time of need. Yes, there was. Can you give me examples of that, Ms. Smith? And Ms. Smith says, yeah, in fact, I kept a journal. And say, would you tell me what those were? Well, I can tell you on September 3rd. So at this point, opposing counsel is going to object and they'll want to view it, which that's fine because you're prepared for that. She didn't put anything in there that she was fearful of the opposing party seeing. So then she resumes her testimony. And she goes down, the court is listening, and she says, yeah, at 11 o'clock on September 30th, I was doing such and such. And then on September on October 5th, this was such. That has far more credibility if you contrast that to the same person on the stand being asked that question saying, yeah, it was in September, and there was one night when he came by and da-da-da-da-da. And there's another night in October when he did such and such. You see the difference between the power of those two presentations?
Yes, sir.
So that
the
is
credibility
one.
goes up on the other one, and then it's objective, right? I mean, it's like it would be pulling up, going, on this date, routinely my ex hypothetically brings the children back late. On the 5th of December, they were 30 minutes late. On the 7th of December, they were 30 minutes late, and I actually called her 15 minutes early to see what was going. That type of thing.
Exactly, perfect examples.
Okay, so evidence by using, so just documenting your situation. I mean, even like MFR, like memorandum for our work, memorandum for records, just some type of way, I mean, a journal would be easier, but just some type of document that says on this date, X happened in a very objective, I mean, almost sterile view would be your best bet?
Yeah, sterile, and if it errs on either side, it errs towards sensitivity. And when you portray the other party, interestingly enough, it makes them look worse if the other party is almost describing with sad regret their horrendous behavior. That's the sort of sympathy that is especially damaging to the opposing party versus the malice and vindictiveness that the court might otherwise impute to motives. So yes, sterility if the alternative is something that is emotionally charged. But even better than sterility is something where you appear, but in fact are not, very sympathetic to this hopeless, destructive, sad behavior of your spouse that has resulted in your and your children having to be in this court.
Oh, okay. That's a really good point. So the last question I had for you is, and we've kind of talked a little bit about it going through the other questions, but really, what is the best thing I could do? Like, if you're my attorney and I'm coming into you, what is the best thing I can do to help you help me in my situation?
One thing that I will tell you is that when parties go in to interview a lawyer in divorce, it's very important for them to find out whether that lawyer appreciates the role that they need to play. I mean, keep in mind that this has to be a team effort. This is not like surgery where the responsibility of the patient client is to simply show up. In this case, this has got to be a team effort. The expert regarding all the facts is not the lawyer. The lawyer is the expert on the law, but the expert on the facts, and one of only two in the world that are experts on the facts, meaning the husband and wife, is the client. So without the client's active participation in helping to put together the case, meaning proposing incidents, proposing occurrences, information with which the lawyer can construct this edifice that will be their case, then the lawyer can't possibly succeed. Yet there are divorce lawyers who arrogantly believe that the client shows up like a patient for surgery, gives them their fees, answers questions as needed, and shows up for trial. I mean, that sort of perspective is not a winning formula. So the first thing I would say in response to your question is there has to be the selection of the right lawyer, the lawyer that's going to include you as an equal partner in this effort that you all have undertaken. And the other thing is to early on find out from the lawyer what is going to be your strategy and what is a reasonable expectation. Now, those things may change over time, but at any given point, it should be clear to the client, this is what I can reasonably expect at this stage, and this is how we're going to get there. The clients have to realize that in order to participate in this way, it does mean that they spend more money. And believe me, many divorce lawyers would rather be able to have clients that get great results without having to spend quite as much money, believe it or not. I mean, I wince sometimes when there's a strategy that I really want to pursue, and yet I know it's going to cost an extra $3,000 in depositions, and I know that I can't do it because it's not in the client's budget. So it means really a heart-to-heart discussion with a lawyer about, what strategies can we pursue here and what can we afford. There are some things that are cheap to put on the stand to prove if there's going to be a trial, and there are other things that are expensive. You need to decide on the early end which one you can do. And remember, you also want a lawyer that wants to prepare for litigation from day one, meaning that it doesn't mean that you want to go to trial. Who would want to go to trial if they could get a good result without going to trial? Paradoxically, it's true that if you and your lawyer, meaning the client and the lawyer, prepare from day one for that possibility that they're going to be in front of a judge presenting this case and they proceed accordingly, I'm telling you, it's amazingly, almost mysteriously, how often that results in a favorable settlement. Settlements don't come from weakness. They don't come from the opposing party believing that their spouse fears a trial or doesn't have the money or the emotions to endure conflict. If the opposing party believes that, believe me, they pounce like a wolf. You only get good outcomes in domestic relations from a position of strength.
That is really some great advice, and I have talked in other videos, or I've done some videos talking about attorneys and what to do, and I've said you need to interview it. You need to, don't just go with the first one, you need to talk to them, and you need to make sure that you have that type of relationship. I really appreciate you saying that. So that wraps up. I really appreciate you taking the time. Is there anything else to talk with this? What you presented was really valuable information. Is there anything you want to say before we end the interview?
The only thing I would say is that, and this seems odd coming from a divorce lawyer, and that's that interestingly, I would say that I believe that most divorces are not the result of the fact that two people couldn't possibly make it. I know that that's conventional wisdom. I think that divorces more often than not result from one of the parties coming into contact with another opportunity, whether it's in the workplace or elsewhere, they meet someone else, but for that I believe that more often than not, they would have been celebrating their 50th anniversary some years down the road. So my point is that I believe that most marriages can be saved. And I think that to the extent that people have the opportunity to think through that decision, and I realize it takes two people. One person can't save a marriage. So some people who are listening to this are probably thinking, I don't have any control over this decision. My husband or my wife has decided they want out. But if I'm talking to somebody who is the one who's initiating that action, perhaps who has met someone else, I'm suggesting that grass is probably not going to be greener on the other side. It's possible it will be, I understand that. But I can tell you from having done this for a long time that more often than not, it's not greener. And that those problems you had in the first marriage, you may carry into the next marriage. Yeah. But the bottom line is I would suggest that people be very thoughtful about their divorce before they charge down the road. It's a tough, painful process. People who go through it will often describe many years later as one of the darkest periods in their lives, whatever the outcome. Yeah. And I'm just suggesting to your listeners and viewers that they should think about it before they make that grave decision.
Great. Well, hey, thank you again for taking the time, and I appreciate you being on the program, so thank you very much.
My pleasure. Thank you for having me on, Dwayne.
Okay, I hope you guys enjoyed that interview. I thought he covered some really great topics and some really good information. I think all of us should really take a step back, really listen to what he had to say, and look at that and how we're trying to interact and deal with our ex. Now, granted, he's talking about it from the beginning stages, but I think a lot of the information he provided really gives us some insight on how to progress forward and deal with things in a constructive way and try to mitigate some of the damage that our exes is doing to us. But bottom line is we have to take a methodical approach and we have to be cautious of how we interact. So I'd love to hear what you guys think about this. I was really glad for Joe to take the time to actually talk to us on the channel, and would love to hear what you guys think about the interview and what you thought about it and what your takeaways are from it as well. And maybe in the future we might even be able to do something like that again. I don't know. We'll have to see how this goes, but hope you guys enjoyed it, and I will talk to you guys on the next video. Take care. Bye.